listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello and welcome to another episode of Driving Law. I'm Kyla Lee at Acumen Law, and with me, my co-host, Paul Doroshenko.
Hello. Happy Friday.
Yes, it's Friday. We have so much driving law related stuff to talk about today. We should just dive right into it. Waste no time. So, I guess the first thing we should talk about is the two festivals that have produced so much media attention and so many tickets and prohibitions.
Yeah. All over the news.
Yeah, so there was the Shambhala festival, which had what was it? I can't remember the numbers now. Do you remember them? You were on the radio about this.
I wasn't on the radio about this. I was on the radio about the changes to the Class 7 to Class 5 licensing scheme. You were the one who was on about the Shambhala. It was well over 100
Yeah.
different driving prohibitions and so
Yeah.
forth.
Yeah, it was 601 traffic stops, 7 excessive speeding tickets, 311 speeding tickets, a ticket for driving without due care and attention, 10 seatbelt tickets, 2 electronic device tickets, 57 vehicles were towed. There were 85 SFSTs done, 30 DREs with 27 drug impaired investigations, 23 blood draws, 50 random tickets, and 8 vehicles taken off the road for mechanical defects. So a lot.
Out of that number of cars, I would expect there to be that many with mechanical defects.
Sure. I just don't understand like how, every year there's been enforcement of people leaving Shambhala. And the police even come out and say, hey, if you're leaving Shambhala, make sure, you're not speeding, you're not doing drugs, etc. Like there were 800 tickets last year. So how do people not know this year that it's going to happen and not, put themselves in a position where they're not going to end up with more charges?
Well, you're assuming that they're guilty. I mean, if they're all innocent, it could be all of those people may have done absolutely nothing wrong. It may just be police heavy-handedness.
All the no insurance tickets?
Okay, no insurance, as you and I know, has become a problem in BC because our insurance renewal comes with a sticker because it's a BC government thing, and as a consequence, people no longer have a sticker on their license plate because they did away with that a few years ago, and people forget that their insurance is expired, and they don't look at the letter from ICBC. And half the time they've moved twice, and they haven't updated their address with ICBC, so they end up with a ticket that's very easy for the police to prove.
Yep. But that wasn't the only music festival that produced record numbers of tickets. So there was the Sunfest Music Festival in Lake Cowichan, and that one, teeny tiny little Lake Cowichan, their previous record in 2024 was 25 impaired drivers. It went down last year. 2025 was only 11, but this year it was up to 36 immediate roadside prohibitions issued during that festival, 2 12-hour suspensions, 6 24-hour suspensions for drug impaired driving. So yet another music festival, yet another big police bust.
Well, here's the thing. I mean, we've talked about this before. It's not an issue of numbers going down. It's more an issue of enforcement. And if you're to pull over more cars going to these things, if you put in the time to have the police there, you will issue more driving prohibitions. And if it was last year, it was 11, and this year it's whatever it is, 28, or what did you say? It could just be an issue of enforcement.
36 this year.
Yeah.
Okay, moving on from that, because there's actually something major that we need to talk about, which is a big Ontario Court of Appeal decision that was released yesterday.
Yes, and you did a TikTok about it, and people were upset.
Well, they should be upset. So this case,
They were upset for different reasons, as you know.
yeah, it's just that nobody can agree on what they're upset about, but they can all agree they're upset. So this case involves the statutory interpretation of the presumption of operation in the criminal code. So it's 320.25 or 0.35 of the criminal code essentially presumes that if you are in the driver's seat of a vehicle, you are there for the purposes of setting it in motion. You can rebut that presumption by adducing some sort of evidence to show that you weren't in the driver's seat for the purposes of setting the vehicle in motion. But the issue that arose in that case was not whether or not the person had occupied the driver's seat for that purpose, but whether or not they could be presumed to be operating a vehicle if the vehicle itself was inoperable. The facts of the case are to me like also a little silly, but I don't know like how all the evidence came out at trial. But apparently this guy's like driving down the road and he crashes his car, wraps it around a telephone pole, and the car becomes inoperable. He's found by the police in the driver's seat. But for whatever reason, I guess there was some reasonable doubt at trial that he was the one that was actually driving the vehicle when the crash happened, which, I think,
Yeah. Well, you can see that. We've had those scenarios.
I don't know, if you're sitting in the driver's seat, it's
Well, it's unlikely it's unlikely, but it still does happen where people will get in the driver's seat for some reason.
yeah, anyway, it's an inference that can be drawn, I guess.
Yeah.
And so yeah, he operated was presumed to be operating the vehicle, but successfully argued at trial that because the vehicle was inoperable after the collision, because there was no realistic risk of danger, he couldn't be convicted. The Crown appealed the acquittal. They won at the summary conviction appeal. The appellant appealed, and he lost at the Ontario Court of Appeal, who ultimately decided that, yeah, it is still the presumption still applies even if the vehicle is inoperable.
But we had all of these cases with snowbanks and things like that, or, no functioning wheels or engine destroyed.
Mm-hmm. Yep.
Has this changed the law? It's gone the opposite direction now?
Yeah, so I guess the whole thing is that and the court gets into this, they like look into the Hansard, and I'm quoting from paragraph 24 here, where the court says, before this amendment, if an accused state of intoxication were sufficiently advanced, the courts of many provinces held that he did not have control of the motor vehicle. It is no longer open to an accused person to defend himself on those grounds. The earlier words in this proviso take that defense away from him, but they leave a defense to a person who, having got into the car for the purposes of setting it in motion, goes to sleep. If a person accused of driving a car while intoxicated could go into court and say, I was too drunk to be guilty, it shocks the public. Indeed, it shocks us all, I believe. It should not be open to say, I was too drunk to be said to have had under my control, even though I was sitting behind the wheel. It should not be open to him to be able to say that. And so then they amended the code to make that no longer a defense.
2018.
Yes. And then amended again. No, sorry, that was the 2008 amendments. And then
Yeah.
2019, they amend again to change the language even further, to basically say you can't be in the driver's seat of the vehicle at all unless it's not your intention to set the vehicle in motion. And we don't even care if the vehicle is inoperable because we don't even want to allow people to put themselves in a situation where a risk might arise.
Well, there's still the one saving grace there that you could take the witness stand and testify about your intention of getting in the vehicle, which wasn't for the purpose of operating the vehicle.
Yeah, but what if it was? Like, I don't understand why Parliament has chosen to criminalize, like, you're drunk. Fair enough. You go to your car that has a dead battery, or it's in the condition that my car currently is in, completely inoperable. There's no risk it could be set in motion. Can't even get it in gear. Um, can't even get it to boot up. Um, and you get in the car and your intention, you're really gonna try and get that car running, but you can't. No matter what you do, you can't. Why is that criminal? Why is that criminal?
Shouldn't be. I
But
agree.
it is.
And I also don't think that the onus should switch to you because it seems to completely eliminate the whole presumption of innocence and burden on the state. But
Yep. Yeah, and then the court's suggesting that, this would create a situation where, somebody who's just been in a serious accident rendering the vehicle inoperable would be treated less seriously than somebody who gets into the driver's seat of their vehicle in a driveway with no intention to drive, but just to sleep there, to separate themselves from their spouse or whatever. And like that's not the function of the law. Like, the law is capable of separating. First of all, nobody in the sleeping from this in the driveway is likely to even be charged. Um, but secondly, like, the law is not going to function to allow people who wrap their cars around telephone poles typically to escape. Right? Most of the time they're able to draw the inference or connect the dots that the person's the driver. That's what the police are supposed to investigate that.
Rare occasion that they can't. I can't think of a scenario that I've dealt with in the last 15 years where they couldn't.
Yeah. So the court says because Parliament didn't write, if A, then B, unless C or D, and just say if A, then B, unless C, if it occupies the driver's seat of the vehicle for the purposes of setting it in motion, unless they can establish it wasn't, or that it wasn't operable, they intended to make it, um, criminal to be in the driver's seat of an inoperable vehicle. There is one minor thing in the judgment that I think is important, and that's at paragraph 49, right near the end of the judgment. The court says it bears emphasizing that this appeal is not a constitutional challenge. The appellant does not ask this court to strike down or read down the presumption on constitutional grounds. This appeal raises a question of statutory interpretation only. So, arguably, you
They're leaving it open to argue.
yeah, you could look at that as them saying, look, like maybe because this does allow people to be convicted in circumstances where there is no conduct that should be criminal, um, arguably that's unconstitutional because it's capturing people who are factually innocent, even if they're not innocent of mind. Right? Like the idea of impossibility, right? Like if you try and murder somebody who's already dead, you can't be convicted of attempted murder because it's impossible to attempt to murder somebody who's already dead.
I've said this before, and I'll say it again. I feel that in every impaired driving trial, everyone should be taking issue by filing constitutional arguments with every aspect of the presumptions.
Yeah, well,
But usually you have some other path to succeed, so that's not why you do it. But all of the presumptions are subject to scrutiny by the court for their constitutional validity, and all of the presumptions are work essentially to have a presumption of guilt.
yep. And if presumption operates such that a person can be convicted even where the trier of fact has a reasonable doubt, that presumption is unconstitutional.
Would seem to me, but
But but the Ontario Court of Appeals excused it in other ways in impaired driving. It's like honestly, like impaired driving and sex assault are the two areas of law in this country where it doesn't actually matter what the normal rules of evidence are, what the normal burden of proof is, what the normal process is, how the rules of fair play and decency function. We throw them all away for those two offenses. They're treated
because it would offend, or could offend.
people would be upset that we have a functioning justice system that's fair,
Yep.
that maybe allows some guilty people to go free to preserve the innocent. Yeah. Anyway,
It's not encouraging.
no, it's not encouraging, and I'm discouraged by it. Uh, let's, however, talk about something else that's not encouraging, which is some conduct of the director of Safe Roads Alberta. This case came across my desk this week, and it was very, very interesting to me. It was a judicial review of a decision, so like Alberta's IRP scheme, basically. The guy, or the the woman files a judicial review. It doesn't really matter what happens in the judicial review, in terms of like the reasonableness of the decision. The decision is upheld, by the court. So she's unsuccessful on the judicial review. But some pretty crappy things happened in the course of the judicial review, well, I guess after the judicial review hearing concluded. So remember when
But before the decision was rendered.
but before the decision was rendered, yes. And when you're an individual, like a disputant in this process, right? It's you versus the government. When you do your hearing, it's government adjudicators. And then when you go to court, it's government lawyers representing a government agency, the people with unlimited resources, unlimited power. Um,
Court is owned by the government.
yep.
Judges get a paycheck from the government, but
Yep. Yeah, it's all government, 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 and then you, the little guys, like truly David versus Goliath, right? So you would think that in those circumstances, the government would be sure to conduct itself with the utmost honor and integrity.
yeah, to ensure that there's not the perception or actual bias in any way, to ensure that the person who's going into court and making that argument in court can feel confident that that judge, although they're paid for by the government, nevertheless will have the courage to act independently in those circumstances, that everything that is argued before the court is there before the court with you there, the little guy, hoping that the
Yes.
judge is getting it and will, rule in a manner that is equally fair to both parties.
Yes. Anyway, so what happened in this case was 3 weeks after the hearing ended, without leave of the court, which would normally be required in these circumstances, without notifying the self-represented litigant opposite, counsel for the director of Safe Roads Alberta, so the government lawyer representing the government body, wrote to the court ex parte, provided 2 more cases that they intended to rely on and 2 pages of additional arguments. No, saying, hey, some new case law has come to our attention that we intend to rely on. We'd like to bring it to the attention of the court. I've canvassed this with Miss, what was her name?
Person.
Alwas. And she opposes it, and so we're seeking a direction from the court. That would be the appropriate thing to do. No. Just send in the argument, send in the cases. And the court, loses it on the government lawyers for this and says that once a matter has concluded and been taken under reserve, counsel may not unilaterally continue the argument by correspondence. If further submissions are thought to be necessary, proper course is to seek leave, identify the reason further submissions are required, and provide the opposing party with a fair opportunity to respond to whether supplemental submissions are warranted. The director's unilateral communication advancing substantive submissions on the merits after the close of argument was inconsistent with those basic requirements. Moreover, the director is not an ordinary private litigant. The concern is amplified by the director's institutional position within a provincially administered regulatory scheme and the fact the director was represented by counsel from Alberta Justice. The administration of justice depends upon public confidence that all parties stand on equal footing before the court. When counsel for a government actor communicates additional legal argument to the court after the hearing has concluded without leave, the resulting concern extends beyond ordinary procedural unfairness. Post-hearing, uninvited communication from government counsel to a judge seized with the matter risks creating the appearance that the government has a privileged channel of access to the court after the public hearing has ended. Whether or not that perception is accurate is not the point. And then they award costs against the government. So Ms. Helwas loses. Ordinarily, the government never has to pay costs, but in this circumstance, yes, they do, because unfortunately, the government lawyer acted badly.
Oops. Um,
That was intentional conduct. Are you kidding? That's about as far from oops as you can get.
I could see the machinations. We've discovered this. We forgot this. We should have brought this up. It's just a self-represented person. We're only officers of the court providing case law to the judge. Let's just send it in. That's probably what happened. And not thinking about the public perception of that, and not thinking about the fact that it's not that difficult to find the person and let them know that you've got some other issue and you wish to bring it to the attention of the court. But interesting that the court was so concerned about it is a good thing, obviously. Interesting that costs were ordered, and yet she wasn't successful in the case.
Yep. So there you go.
Yeah.
Let's talk about our
ridiculous driver of the week.
I enjoyed this one.
Remind me which one it is.
This is a sedan, a BMW
Oh,
318i. I don't know, you probably know better. In West Vancouver, driving on the Sea to Sky Highway with 2 oil drums, the big oil drums, strapped to the roof,
steel drums.
not properly secured, and filled with vegetable oil. So overweight, improperly secured, and just really foolish. Really, really foolish.
Just waiting to be spilled all over the road.
Yeah.
To roll off that roof and land in somebody's windshield.
Yeah.
On top of, like, that's a small BMW. It's not designed to take a ton of weight. You know, 4 people is sort of the extreme on that.
The West Van police shared a picture of it, and you could actually see that the 2 oil drums side by side are wider than the car itself.
You had a roof rack or something, or you throw some 2x4s on it or something?
It looks like, it's hard to tell from the picture, but it looks like there's like a wooden pallet, and the oil drums are on top of the wooden pallet.
Great.
Yeah.
I wonder how he got him up there, unless he'd like pumped the oil in after the fact.
How do you lift that? Yeah. And then how
Forklift, but like you would think if you've got a forklift, you might have a forklift driver who would have some good sense to not do it.
one would think, but apparently not.
Well, I'm on that corner of TikTok where we see people loading and hauling strange things with their vehicles.
I mean, yes.
Strapping a pallet to the back of their SUV with the tailgate open and the pallet on the ground and 2 skateboards under either side of the pallet and driving out of the parking lot of Home Depot. So this is akin to that, I guess.
Yep. Pretty much.
I could be the ridiculous driver of the week because when I was about 22, I fit an entire sofa on top of a Nissan Micra at IKEA, and I drove it across town in Edmonton.
I feel like that's not
Not as bad as liquid
like
barrels of oil barrels.
that's not likely to be the ridiculous driver of the week either, because you did it so long ago.
No, I know I made it, and I never will be the ridiculous driver of the week, I hope. I like to think I'm more sensible than that.
Yeah, fair. Okay, well, that's our podcast. If you have a driving law related issue, you can find us online at vancouvercriminallaw.com or give us a call at 604-685-8889 and tune in next week for another exciting episode of Driving Law.